matter to come before the court this morning is Robert Mihiylov versus Ohio Edison Company and Nelson Tree Service.
I think that's Mr. Mihiylov.
Are you Mr. Mihiylov?
Yes.
Come on up. Am I pronouncing your name correctly, sir?
Yes.
Okay, good. Both sides will have 15 minutes to present oral argument this morning. The appellant may reserve up to 5 minutes for rebuttal. For the appellant, you wish to reserve that time, you let me know when you get started. I'm keeping the clock and keep you apprised of the passage of time. We've read the briefs, so ready to proceed in the morning.
Okay, may it please the court, Stephen Tonka, Retzel and Andrews, on behalf of the appellants. I'd like to reserve 3 minutes of my time for rebuttal. This appeal relates to a challenge to the trimming of trees in connection with Ohio Edison's vegetative management program. In this regard, the first question before the court is whether the trial court erred in denying our motion to dismiss for lack of jurisdiction. And on that issue, the Supreme Court's opinion in Corrigan versus Illuminating Company is controlling. And in that opinion, what the court held was essentially that in making the determination as to whether a complaint falls within the exclusive jurisdiction of the PUCO, the court should review the substance of the claim, see if there are any service-related issues involved. It's only in a situation where it's a pure, that's the word they use, pure tort or contract claim, that the trial courts would retain jurisdiction. And so basically the model that's been set up by the Supreme Court is if the claim, even if it's a common law claim, if it's a common law claim that would involve the court in making determinations of service-related issues, then it would fall within the exclusive jurisdiction of the PUCO. Now, if you look at this transcript, you look at the complaint, and you look ultimately at the trial court's decision, it's very clear that the substance of the claims was service-related, involved service-related issues. The primary claim in this case was a negligence claim. And in order to, that claim alleged that Ohio Edison Nelson Tree Service violated its own vegetative management standards in trimming the tree. In order to decide that claim, the trial court had to become involved in making resolving service-related issues that fell within the administrative expertise of the PUCO. And that's clear if you read the trial court's decision. Actually, on page 1 and 2 of the opinion, she begins by saying that the plaintiff contends that Nelson cut trees that posed no threat to power lines, and that it involved excessive and unnecessary pruning. So the question that the court had to decide is, was there a threat to the power lines, and was it necessary to trim the trees? That's exactly the type of issue that the PUCO would have jurisdiction to resolve. And then in the actual opinion, when she deals with the negligence claim, her opinion begins by saying that she determined that there was a 10-foot distance that was required under industry standards that had been adopted by Ohio Edison as part of its vegetative management plan. That's from her opinion on page 9. And then she finds that the defendants were negligent because they ran afoul of their own pruning standards when they cut the tree. That's the nature of the negligence claim. So when you look at it, she clearly is having to decide first of all, what are the applicable standards that govern the trimming tree. That's the standards that are set forth in the vegetative management plan that's approved by the PUCO. And then she's having to define that they're negligent because they quote-unquote violated those standards. Now, the trial court, when you actually read the order denying the motion to dismiss, she acknowledges in that motion that this does involve service-related issues. In fact, she writes on page 5 of her opinion, this is the October 23rd order, that the plaintiff admitted that he was attacking Ohio Edison's plan, and she goes on to say, it is clear that plaintiff is directing his arguments to the tree trimming program set forth in the plan. So what the trial court does, though, she says, okay, even though it's a service-related issue, I'm going to deny the motion to dismiss because the PUCO lacks authority to award money damages. That's the basis of her decision. That is legal error that is clearly reversible by this court because, as spelled out in our briefs, the PUCO statutes do provide a mechanism, a procedure for the recovery of damages. Indeed, if you look at Corrigan did not turn on whether a claim alleges for money damages. in any tree trimming case, it's often going to be the case that somebody is suing for money damages. That's not what is the determinative factor. What's the determinative factor is whether the claim involves a service-related issue. Now, this court recently, in another opinion, Berry versus Ohio Edison, and we actually submitted it as a notice of supplemental authority, addressed a similar circumstance. In the Berry case, however, the ultimate issue was very different than what we have here. In that case, the facts turned on the fact that the property owner alleged that Ohio Edison had previously erected a power line in a different location, such that the wires crossed over the property owner's property. And that was the nature of the trespass claim in that case, because he alleged that the lines and the trees at issue were located on his, or not the lines, not the poles, but the lines were located on his property, and that's what necessitated the tree trimming. Ultimately, the court was unable to resolve the jurisdictional issue and was unable to resolve the trespass issue because there was an incomplete record. So they didn't make any factual findings as to whether or not there was any legal findings either, as to whether or not there was jurisdiction or whether or not there was a trespass. But we don't have that problem in this case because we've made taken extraordinary efforts to make sure that the record is complete. We've identified all that in our notice of supplemental authority. But more importantly, in this case, and this is clear from the record, the plaintiff never argued that the poles and the wires were not in fact located within the public right-of-way. So that was not even an issue in this case. He actually conceded this point on page 37 and 72 of the transcript. So when you actually look at the substance of his claims in this case, it clearly involves a service-related issue. Now, he does allege negligence is the primary claim in the case, and that's the primary thing that the trial centers on. All the evidence centers on what is the industry standard and what's it violated in this case. There is a trespass claim also alleged, but that trespass claim related to an issue as to whether some of the branches in the canopy of the tree was or was not inside or outside the right-of-way. The problem with that claim is that there's really no competent evidence in the record to establish what the actual legal boundary of the public right-of-way was. And the trial, the plaintiff contended, and the trial court basically assumed, that the right-of-way boundary was marked by the edge of the sidewalk. Well, that is not necessarily the case. Public right-of-way is generally usually larger than the sidewalk because you have to construct the sidewalk within the right-of-way. That's not our problem, that's his problem because the plaintiff bore the burden of proof at trial. And so to just say that the sidewalk is the boundary of the right-of-way is not competent evidence. There was no evidence to establish what the actual legal boundary of the right-of-way was. But also, the only evidence of trimming of trees was a photograph. And if you look at the record, it's exhibits 1 and 2. There were 2 photographs. And there were aerial photographs taken from the ground showing a hole in the canopy of the tree. But when you look at the photograph, there's wires right in the middle of this hole. And so looking at that photograph, by that photograph alone, you cannot make any determination. You know that there was trimming of trees, but you don't have any determination as to whether or not the trimming was inside or outside the right-of-way, because there's no demarcation as to what the legal boundary of the right-of-way is, let alone to establish that there was an actual trimming outside of the right-of-way. So the trial court's opinion is essentially based upon a false assumption, and so therefore there is no competent evidence for the trespass claim. And I say that because one of our assignments of error relates to the trespass claim, but ultimately the primary claim in this case was a negligence claim. So even if there is an issue of trespass, whether or not that's within the jurisdiction of the PUCO, the ultimate, because the resolution of this particular case did in fact involve service-related issues, it therefore has to fall within the exclusive jurisdiction of the PUCO, because this case illustrates why the Supreme Court decided Corrigan. They did not want trial court judges getting involved in the complicated expertise issues relating to whether a tree would cause a threat to a power line. In fact, what they said in Corrigan is if it's even threatened to cause damage to a power line, that is something that the PUCO has the administrative expertise to resolve, and we want those claims to be resolved there. Let me, with the rest of my time, just to briefly address the other assignments of error in the case. So to wrap up on the jurisdiction, we think that primarily the way this court should resolve this case is to dismiss, to reverse and to order that the case be dismissed for lack of jurisdiction because the case involved the resolution of service-related issues. But on the other assignments of error, which were based on the assumption that there is jurisdiction, there are other additional reasons for reversing. First, on the negligence claim, there was no testimony, expert testimony, or any other testimony from a competent witness to establish what the actual standard of care in the industry was at the time of the trimming. There were some printouts of some websites, and then Mr. Mihiylov testified that he had previously worked in the electrical industry, but he was not, that was years ago, and he was not competent to testify to the standard of care at this time. So there was no qualified expert.
Weren't some of the printouts though from Ohio Edison's, weren't they Ohio Edison's documents taken from the internet?
Actually,
Do I recall that correctly or not?
actually, if you look at it, it's Exhibit 3 and I think 4. They were from, one of them was from AEP and the other one was from another company. I just don't know, there may have been an Ohio Edison one too, I just don't remember. I did note that there were some from other companies. But ultimately, what ultimately came down was there was, I would say that doesn't necessarily establish what the industry standard would be. There was really nobody that talked about that was violated in this particular case. Because the key thing is, was the trimming necessary for the trimming of this particular line? And that would really be a fact-specific analysis of applying the standard to the actual trimming that was done. So that's an additional reason for why the court should reverse the verdict. There also was no competent evidence to establish damages. Now, the court in this case awarded $1,000 in damages, and she based that on the principle of law that says that the property owner can opine on the fair market value of their own property. Now, that case law deals with the fair market value of real estate. In this case, we're talking about the value of trees, and not even the value of trees, we're talking about the value of branches. That's the only thing that was trimmed. There wasn't any trees removed or anything like that. And these are branches that are going to grow back. So we don't really have any competent evidence to establish the value of the branches that were trimmed. So what happened then, the judge just basically speculated and said, we'll give you $1,000. Now, on the third part, the last assignment of error that we alleged in our brief, the trial court in this case committed a reversible error because she made a credibility determination about one of the witnesses based upon what he testified in another case. And the case law is very clear, we put it in our brief, that you can't do that. You can't rely on evidence from another case in order to decide this present case.
And you just now reached that 3 minutes.
Okay. So for all those reasons, we ask the court to reverse. We think the primary reason is to do jurisdiction. If the court does reach the verdict or the judgment on the merits, that we believe that there is insufficient evidence to support those liability findings and that and the damages, and we ask the court to reverse that as well. Thank you.
Thank you. I filed yesterday a summary of my oral argument. I presume you received it. I'll try to be brief, not read through the whole thing. Opposing counsel is correct in that prior to becoming an attorney, I did become an electrical engineer at BSE from Akron U, and I did design power lines. And one of the things I had to say was that the laws of physics haven't changed. They're the same when I was a power engineer for tree clearances and so forth as they are today. But be that as it may, one of the points I wanted to make was that these were just not that it's necessarily pertinent to this, but they are not random trees. When I moved into this property, I paid a service $800 a tree to move two 20-foot, 2-ton trees into my front yard. Before I did that, I used my engineering expertise to calculate what their maturity and growth rate would be so they wouldn't interfere with the Edison lines, and they never have. They in fact reached maturity about 12 years ago, which I'll get into later. When I found out that this was going to come to fruition here, there was a card left on my front door to call the number. I met with an Edison Nelson representative. I thought his name was Leisure, who's a supervisor for Nelson, but I could be wrong about that. The supervisor told me that he had authority to dictate how the trees would be pruned. We looked at my tree. The branches that were into the public sidewalk were just small, not very far protruding, and low. They were near the heights of the cable and telephone lines, not at the high level 13,200 volt power lines at the top. We made an agreement that he would just prune to the edge of this, where my sidewalk meets, where the sidewalk meets my front yard. I told him if that's not satisfactory, I will at my expense hire somebody to come in and prune my trees back to whatever you say. And he said, no, that's not necessary. We'll just prune to the sidewalk. Based on that, I relied on his agreement with me. So actually, this isn't just about negligence. I try to present this also as a contractual matter.
No
And
writing on that agreement.
no writing, it's all oral. I can't prove that it was done. But the other side never denied during both hearings, both the motion hearing and the trial, they never denied that that meeting did not take place, and they never denied the content of what I said was in the meeting. So they never refuted my testimony. At any rate, they entered my property without my knowledge or permission, because obviously I thought they were going to prune differently. They came back about 10 feet into my property and pruned trees that the limbs weren't even at the level, height level of the power lines. I don't know why they did that. At any rate, what I did then was obviously filed this case in Akron Muni. The exhibits P3 and P3A and P3B in my trial, showed P3 was a direct copy of the Edison website that clearly showed there's a 10-foot clearance all the way around the 13,200 volt power lines that are at the top of the poles. The middle lines on the pole are 220 volts. They go to houses, they're distribution lines. You can run those up to your house against a tree, it doesn't matter. Those aren't a problem. And the lower lines on a pole are all cable and telephone lines. At any rate, the P3A was probably going to forget this, I think it was Consumer Energy. It was Michigan's largest power distributor. And that was also a 10-foot clearance around 13,000. Actually, it's up to 14,400 volts. That's the 10-foot required clearance by the electrical code. And then also American Electric Power, my Exhibit 3B, same thing. It's 10 feet. It's 10 feet everywhere you read in the electric code, on the websites, all the power companies. That's the clearance required. So my first statement is that on the Corrigan case, Allstate is used by Corrigan, that it's not necessary to have the PUCO's, quote, expertise involved in this, because there's nothing that the PUCO can determine that's different than what's on the Edison website. It's already published and published in every other power company website. 10 feet is the clearance. If you say the PUCO needs, we need their expertise, what is it they're going to be an expert on? There's really nothing for them to make a decision on. Also, we're talking about the easements. In Akron, Ohio, this is what I determined from my research and from several phone calls that I made to Edison. There's no recorded easements in Akron. I searched the clerk's office. Any power lines that are in the tree line, or double strip as we call it, they're right-of-way, or their easement is the public right-of-way, which includes the street, the tree line, and the public sidewalk. Doesn't go beyond the public sidewalk. And that distance, by the way, as measured in my exhibits 6 and 7, trial exhibits 6 and 7. It is 10 feet from the center of the pole line to the edge of where the public sidewalk meets my front yard. It's exactly 10 feet. In fact, in my pictures, P6 and P7 in the trial, you can clearly see I shot both looking down the street and up the street before the pruning was done. If you look at these pictures, you can see that not only are my limbs not even close to the upper limbs, not only close to the sidewalk edge, they're way below the level of the 13,200 volt power lines, which are the subject of this case. The lower ones don't matter. They're not critical. In fact, I think I put in an exhibit, I think it was P4, where I actually put in a picture of it, of a regular pole with the power lines above, the transformer stepping the voltage down to the distribution, and then the cable and phone underneath. But it's the upper lines that are the problem that you have to be careful of. They basically, as I said, entered my property 10 feet to prune these limbs that did not need pruning. And then at the same time, when I observed what happened afterwards, I took my camera and I went down the street, and less than a block from my house, I have pictures or exhibits P8 through P12 in my trial, where there's limbs and large limbs and branches that are within a few feet of the power line that Edison and Nelson never trimmed. I have some a block from my house and about 2 blocks from my house. So in my opinion, and again, it's just my opinion, their service, if you want to call it that, service-related issue, they're not pruning trees. They're pruning trees in a I don't want to use the word ambiguous, but a negligent manner, and they're not being consistent with their standards. So it's kind of bothers me that Edison would be allowed to invoke the service-related clause of Allstate while they in fact are not even performing the service in a proper manner. The other thing too is I was told, both in the appellant's brief and just now, that I was attacking the vegetation management program. I made a statement in the motion hearing, I think it was, that I was kind of misleading. I said I'm not exactly attacking the vegetation management program, because you're not supposed to be doing that. But I was trying to explain to the court, and I thought I did satisfactorily explain, that what I was attacking was the non-uniform way that Edison's pruning these trees. They come in my property, prune 10 feet back, a half a block away. There's huge limbs that are in my exhibits P8 through P12 that are right by the power line.
Well, maybe they haven't gotten to those yet.
No, they did all their trimming. This was at the end of the summer. And in fact, they're still there as of this morning when I left.
So would your argument be that even if the tree was in a right-of-way, if there was a 10-foot clearance, it's still?
If a tree, say that again, if a tree.
Let's assume that the tree is clearly in a right-of-way, within an easement. As long as there's this 10-foot magic number that you've got, this 10-foot clearance.
Are you saying the tree or the limbs are in the public right?
Well, let's say the tree, for instance. Let's say
Well,
there's a tree within the easement. Would you agree that that would be
Well,
part of the management plan, and that
well, a tree within the easement would be on public land. That wouldn't be on private land.
so your 10-foot rule wouldn't apply to that?
The 10-foot rule applies to any trees. Yes, it applies to
Within
any
or
tree.
without, even if it's?
Within or without.
Okay. I just want to make sure I've got your argument.
Right, but a tree in the public way is not a private tree, it's a public tree.
Okay.
A tree in a tree line, they do the claw thing around which looks terrible, by the way. At any rate, so my position is that both parts of the 2-part Allstate test, as espoused in Corrigan, were not met. There was no need for PUCO's expertise because the writing's already on the wall. And Edison's website and every other website is to clearance. And the second part, which maybe is more arguable, is that I felt that it wasn't service related because they don't perform their service in a uniform manner. And as I said, I didn't attack their vegetation program directly, just the negligent pruning part. So right now I have contract and I have negligence as two of my issues. Also, in the transcripts, Edison Nelson admitted, I think it was a motion hearing, that the PUCO has no authority to award compensatory damages to someone that's damaged. I called the PUCO, talked to 2 or 3 people down there, which I believe I put in the transcript. Same thing. They said, all we can do is slap the utility's wrist and say, you can't do this and here's your punishment. They can't compensate a homeowner who's been damaged. And what they said about the PUCO, there's other recourse. The recourse is to go back to civil court because that's really the common police court or immunity court are the only courts that can award compensatory damages. The PUCO is a regulatory commission. It has no power to give compensatory damages. As far as assessing the damages, the trial court, in their opinion, cited 2 cases, Jones versus Dayton Power and Light and Smith versus Padgett. I cited 3 cases in my brief that I filed post-trial, my closing argument, post-trial brief that we were allowed a week to file after the trial. And I cited Valagore versus Cuyahoga City Board of Revision, Reynolds versus Bauer, an unpublished decision in the Montgomery County Court of Appeals, and Kaiser versus Franklin, Ohio 10th Appellate District. All those cases say the same thing. A property owner who's lived on his property has the ability to competently testify in court as to the diminution in value of his property, both because of what previously was worth versus what it's worth afterwards. That's my decision to make. That's not, I don't need to be an expert on real estate appraisals. And the trial court properly found I can do that. And I agree with that. In fact, as I said, that was in my post-trial summary. The last thing is this issue of Mr. Berry's case, which actually was a companion of mine, it was heard right before mine, that the judge used Berry's testimony in Berry's case against the appellants. Actually, there were 2 witnesses they had. They had Mr. Leisure, who was a Nelson Tree guy. He said that basically, I'll just read this, their supervisor was not qualified as an expert to begin with. He did not know the website clearance. He gave conflicting testimony on tree growth. He had admitted my trees were close to each other and would not reach full maturity. And he's also, the biggest thing he said was that in his 12 years of working for Nelson, they never made a mistake in their pruning. Edison's Michael Young said that he saw my Exhibit P3 Edison website 10-foot clearance, but he never saw it, he did not see it. But he oversees that department, and the judge thought it was unusual. He would not even know it's over in his website on a department that he oversees.
And Mr. Mihiylov, I regretfully need to inform you, you utilized all of your 15 minutes of time this morning?
I have?
Yes, you have.
Okay.
So, thank you very much for your presentation. You have a little over 2 minutes.
Thank you. I'll be brief. First of all, there is no contract claim in the case, and that was not a subject of the trial. The judge didn't make any rulings on a contract issue. But the main thing I want to emphasize is jurisdiction. And just to clarify a couple things, I think when you heard the argument from the plaintiff, it really re-emphasized, I think, why this case is fall within the scope of PUCO jurisdiction. Because the operative statute that Corrigan is based on 4905.26 really is written very broadly. It relates to any service which would include whether something is being done unjustly discriminatory, affecting or relating to any service furnished by the public utility. And so what the Supreme Court has said is that the management of vegetation is a service-related issue. Why? Because it directly affects the ability of Ohio Edison to provide reliable and safe electrical service to its customers. And the management of that is a highly regulated area. That PUCO has to approve the vegetative management plan, and any issues relating to whether or not Ohio Edison violated that plan, whether or not the trimming of a tree was necessary, whether or not Ohio Edison was negligent in how it trimmed trees, whether or not it was discriminatory in the implementation of that vegetative management plan, all of those claims fall within the scope of the PUCO jurisdiction. And you may ask, why are we here over one tree? But ultimately, this matters very much. This is a much bigger picture for Ohio Edison. They have very complicated vegetative management programs that they have to manage across the state. And they're watched very closely to ensure that they actually do that management properly. And this is a highly regulated area. It affects the safety of citizens throughout the state of Ohio. And the Supreme Court also made the determination that they don't want trial judges making those very complicated decisions. And ultimately, that's something that we want to have the PUCO make. And the way it works is the PUCO would make a determination, and then the statute provides that you can then, at that point, seek a claim for damages based upon that determination of violation. But the question of whether or not there was, in fact, a violation is ultimately for the PUCO.
Really, you're talking about consistency,
That's right.
not the trial courts. I just want to make sure you're not saying trial courts aren't competent, it's just really consistency.
Right. Well, I think that.
I understand you're arguing expertise, but.
Right, and I guess what I'm saying is administrative expertise. And also I think that another value of that is consistency and ensuring that it's all regulated in a consistent manner. Because this is just not about one tree, it's about trees throughout the state of Ohio. So we ask the court to reverse and to instruct that the case should be dismissed because in this case, it did involve a service-related issue and that it did fall within the scope of the PUCO jurisdiction. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to all sides, as well as posted on the Ohio Supreme